Further question practice. One. In the English system of courts, which of the following offences would only be heard at a magistrate's court? Summary offences. Triable either way offences. Indictable offences. Correct. Incorrect. The correct answer is summary offences. Summary offences are minor offences that would only be heard at a magistrate's court. Indictable offences are serious offences that would only be heard at a Crown Court. A triable either way offence is one where the accused has the choice of which court will hear the case. Submit reset, 1 mark. Submit. Reset. 2. In the English criminal law system, which court would hear an appeal regarding a decision by a magistrate's court? The Supreme Court. The County Court. The Crown Court. The Court of Appeal. Correct. Incorrect. The correct answer is the Crown Court. In the English criminal law system, an appeal regarding a decision by a magistrate's court would be heard by the Crown Court. Submit reset, 2 marks. Submit. Reset. 3. In the English civil law system, which two of the following are the parties involved in a case? Prosecution. Accused. Defendant. Claimant. Correct. Incorrect. The correct answers are defendant, claimant. A civil law case is between the claimant and defendant. A criminal law case is between the prosecution and accused. Submit reset, 2 marks. Submit. Reset. 4. In the context of English law, which of the following is not an advantage of binding precedent? General legal principles are established. The law is based on actual, rather than theoretical, cases. Mistakes by judges are eliminated. The law is flexible and can develop with changing circumstances. Correct. Incorrect. The correct answer is, mistakes by judges are eliminated. Mistakes by judges can never be eliminated. The other statements are advantages of binding precedent. Submit reset, 2 marks. Submit. Reset. 5. In the English legal system, one role of a judge is to interpret statute law. Which rule of statutory interpretation considers what the legislation is trying to achieve? Golden Rule. Purposive approach. Literal rule. Contextual rule. Correct. Incorrect. The correct answer is purposive approach. Under the purposive approach to statutory interpretation, the purpose, or what the legislation is trying to achieve, is considered. Submit reset, 2 marks. Submit. Reset. 6. Which of the following is an example of a standard form contract? A contract between a mobile phone company and a private individual. A contract of employment between a private individual and a small local shop. A verbal agreement between 2 private individuals. A contract for the sale of a house between 2 private individuals. Correct. Incorrect. The correct answer is a contract between a mobile phone company and a private individual. A standard form contract is a document set out by large organizations that states the terms on which its customers will do business with it. There is no negotiation, either the customer accepts the terms or goes elsewhere. The contracts in the other options include scope for negotiation. Submit reset, 2 marks. Submit. Reset. 7. In the law of contract, which of the following would be regarded as valid, binding acceptance? A tender to perform one task. Posting a letter of acceptance. A counteroffer. Acceptance subject to contract. Correct. Incorrect. The correct answer is posting a letter of acceptance. The postal rule states that acceptance is valid when a letter of acceptance is posted. The other options are not regarded as acceptance. A counteroffer is, in effect, a new offer. Acceptance subject to contract means the offeree is agreeable to the terms but the parties should negotiate a valid contract, and a tender to perform a task is an offer. Submit reset, 2 marks. Submit. Reset. 8. Which of the following statements regarding the adequacy and sufficiency of consideration is correct? Consideration does not need to be sufficient but must be adequate. Consideration does not need to have a value to be sufficient. Consideration is sufficient if it has an identifiable value. Correct. Incorrect. The correct answer is, consideration is sufficient if it has an identifiable value. Consideration must be sufficient but not necessarily adequate. It must have some identifiable value to be sufficient. Submit reset, 1 mark. Submit. Reset. 9. Which of the following statements regarding consideration is correct? Consideration can be in the form of any act, even if that act is impossible to perform. Performance of an illegal act is valid consideration. Past consideration is sufficient to create liability on a bill of exchange. Suffering some loss or detriment is not valid consideration. Correct. Incorrect. The correct answer is, past consideration is sufficient to create liability on a bill of exchange. Past consideration is sufficient to create liability on a bill of exchange. This is one of the few exceptions to the rule on past consideration. Suffering loss or detriment is valid consideration. Impossible or illegal acts are not valid consideration. Submit reset, 2 marks. Submit. Reset. 10. Which of the following statements concerning the incorporation of terms into contracts is correct? A history of consistent dealings between the parties is not sufficient to incorporate terms into a contract. Particularly unusual or onerous terms in a contract must be sufficiently highlighted. A person is not bound by a contract they have signed if they have not read it. Correct. Incorrect. The correct answer is, particularly unusual or onerous terms in a contract must be sufficiently highlighted. Particularly unusual or onerous terms must be highlighted. Previous consistent dealings can be enough to incorporate terms into a contract. A person is deemed to have read a contract if they have signed it. Submit reset, 1 mark. Submit. Reset. 11. A term may be implied into a contract by statute, trade practice, unless an express term overrides it, the court, to provide for events not contemplated by the parties, the court, to give effect to a term which the parties had agreed upon but failed to express because it was obvious, the court, to override an express term which is contrary to normal custom. 2, and 3. 1, 2, and 4. 1, 4, and 5. 1, 2, 4, and 5. Correct. Incorrect. The correct answer is 1, 2, and 4. Courts will not imply factors outside the contemplation of the parties or override an express term. Submit reset, 2 marks. Submit. Reset. (12). Which of the following describes liquidated damages? A specific sum payable in the event of a breach of contract. A genuine pre-estimate of losses payable in the event of breach of contract. A sum equal to the amount of work done plus an element of profit that is payable in the event of a breach of contract. Correct. Incorrect. The correct answer is a genuine pre-estimate of losses payable in the event of breach of contract. Liquidated damages is a genuine pre-estimate of losses payable in the event of a breach of contract. A penalty clause is a fixed amount payable on breach of contract. Submit reset, 1 mark. Submit. Reset. (13). Which of the following statements in relation to damages for breach of contract is correct? In order to claim damages, an innocent party is required to take reasonable steps to mitigate their losses. Damages are not payable in relation to mental distress. Damages to rectify a defect are still payable even if they are wholly disproportionate to the size of the breach. Damages in the form of a penalty clause are valid and enforceable. Correct. Incorrect. The correct answer is, in order to claim damages, an innocent party is required to take reasonable steps to mitigate their losses. Innocent parties are required to mitigate their losses. Damages are payable in respect of mental distress, although the scope of such payments is limited. Damages that are wholly disproportionate to the breach are not payable. Ruxley Electronics and Construction Limited v. Forsyth 1995. Penalty clauses are void and not enforceable. Submit reset, 2 marks. Submit. Reset. Jane's boat. (14). In January, L offered to buy Jane's boat for £3,000. Jane immediately wrote a letter to L saying, "For a quick sale I would accept £3,500. If you are not interested, please let me know as soon as possible." L did not see the letter until March, when she returned from a business trip, but then replied, "I accept your offer. I trust that if I pay £3,000 now, you can wait until June for the remaining £500. On receiving the letter, Jane attached a sold sign to the boat but forgot to reply to L. Task 1. Which of the following correctly describes the content of Jane's letter to L? An acceptance. A counteroffer. A revocation. An offer. Submit reset, 2 marks. Submit. Reset. Correct. Incorrect. The correct answer is a counteroffer. L's offer of £3,000 is an offer, so therefore Jane's letter, which changes the terms of the offer, forms a counteroffer. Task 2. Which of the following statements concerning the content of Jane's letter to L is correct? The content is valid indefinitely. The content expired the day after the letter was delivered. The content is valid for a reasonable time. The content was never valid. Submit reset, 2 marks. Submit. Reset. Correct. Incorrect. The correct answer is, the content is valid for a reasonable time. There is nothing to indicate that Jane's counter-offer is not still open in March. An offer may be expressed to last for a specified time. It then expires at the end of that time. If, however, there is no express time limit set, it expires after a reasonable time. Task 3. Which of the following statements concerning the situation between Jane and L is correct? There is an open offer from L but no acceptance from Jane. There is a valid contract between them. There is a valid offer and acceptance but no consideration. There is no contract due to lack of intention between L and Jane. Submit reset, 2 marks. Submit. Reset. Correct. Incorrect. The correct answer is, there is a valid contract between them. Following Butler Machine Tool Company v. Excello Corp., England, 1979, a counteroffer introduces new terms, price. The price is therefore £3,500. As to date of payment, it would appear that the attachment of a sold sign to the boat is confirmation that the revised terms proposed by Jane are acceptable. Submit all, reset all. Submit all. Reset all. Total equals 6 marks. (15) In the context of the tort of negligence, what is the legal effect of res ipsa loquitur? The claimant must prove that they acted reasonably. The claimant must prove that the defendant was negligent. The defendant must prove that they were not negligent. Correct. Incorrect. The correct answer is, the defendant must prove that they were not negligent. Where res ipsa loquitur applies, the burden of proof is reversed and the defendant must prove that they were not negligent. Submit, reset, 1 mark. Submit. Reset. (16)